Line 29, Benjamin Friedland versus Kyle Jeffrey Sandler.
All right, I am seeing Mr. Sandler, the respondent in this matter, is appearing by Zoom. Is Mr. Friedland on the Zoom call?
I am, Your Honor.
All right. We are here on an order to show cause based on filings by Mr. Friedland alleging that Mr. Sandler is in contempt of court for violating a harassment restraining order that was issued by this court previously. Mr. Friedland, did you wish to be heard further on your motion?
Yes, Your Honor. I do have a very brief statement, if it's okay.
Go ahead.
Your Honor, my concern is not isolated criticism or disagreement. My concern is that the respondent, Kyle Jeffrey Sandler, continues to publicly target and identify me despite clear knowledge of this court's temporary restraining order. The respondent has already directly referenced me previously, which is outlined in my earlier filings and exhibits that I've submitted. After the order was issued, instead of stopping, Mr. Sandler publicly acknowledged the existence of the temporary restraining order. And he stated that he would not use my name because there is a temporary restraining order. That is an exact quote from an exhibit that I filed for your review. He then proceeded to continue identifying me through publication, my reporting, my background, and reference to my witness security participation, and has allegedly reviewed my Bureau of Prisons records, which are private. To me, this demonstrates that Mr. Sandler understands the order, but continues testing the boundaries of it rather than complying with its purpose. I have attempted to carefully document these incidents and submit the supporting evidence to the court, including transcripts, recordings, affidavits, and witness information where available. My concern is the continuing pattern. Even after the temporary restraining order was issued, the conduct has not stopped. The references are ongoing, public, and directed towards me. I respectfully ask this court to consider the totality of this conduct to recognize that indirect identification can still undermine the purpose of the order and to enforce the temporary restraining order in a manner that prevents continued circumvention and escalation. Thank you, Your Honor.
All right, thank you, Mr. Friedland. Mr. Sandler, could you turn your camera back on, sir?
Yes, sir. Yes, Your Honor.
Do you wish to be heard with regard to this order to show cause?
Absolutely, Judge Smith. I appreciate you allowing me to appear by Zoom. I live in Florida and have stage 5 kidney disease requiring dialysis, so I couldn't excuse me, safely travel to Minnesota. But I am here to address these allegations directly. I want to also make sure that no party is recording, live streaming, or broadcasting this remote proceeding except for the official court record. Mr. Friedland has been continuously publishing articles about me, my company, my medical condition, and court case. And I've never addressed Mr. Friedland directly, rather the publication, his blog, The Human Intelligencer, where he keeps making libelous and slanderous remarks about me and my company without any bona fide information to back that up. I'm not trying to restrict lawful. Friedland took out this restraining order after initially contacting me. He wrote a blog post about it, saying that not only did he contact me, he contacted me with the privately listed number. He egged me on in the phone call, and then I admit to saying for him to come down to Florida and face me like a man. Obviously, I live thousands of miles away. I've never contacted him directly, and I never would. But if he's going to publish articles about me, I should be allowed to defend myself. And if anything, what I'd ask the court to do is, if you would like or can, make this a bilateral mutual restraining order so that he can cease publishing false articles about me. Because what he does, he has a repeated history for a number of years of instigating people through online platforms and then seeking to weaponize the justice system, the court, and monopolize the time. I don't know if you have it, but we filed a 92-page motion with the exhibits with the court. I received something that I have to pay a fee, which we will, but it shows a pattern of him egging me on and then getting a reaction and then hiding behind the restraining order. The restraining order was sought immediately after my attorney, Monique Pope, sent a cease and assist to him. Not only did he ignore the cease and assist, he referenced the cease and assist and proceeded to say, talk about the lawyer's background on his public forum. And then when I reacted also on my public forum, he sought the protection of a restraining order in Minnesota. In all actuality, Your Honor, I have stage 5 kidney failure, cannot travel by plane. I'm 5'6", and I invited him prior to this to come and see my business and the things that he was reporting on because they were false. I actually even offered to pay for this months before this happened, and he didn't want to take me up on that. So all he is doing is pandering and continuing his repeated conduct of weaponizing the justice system through his public forum, egging people on, and then seeking relief through matters like this. Thank you for your time, Your Honor.
All right, thank you. Well, here's what I'm going to do. I'm just looking at the history of this matter. There was an ex parte order issued by this court back on March 13th, 2026, based on Mr. Friedland's application and the assertion that the alleged conduct that Mr. Sandler was engaged in as far as making threats toward Mr. Friedland and as well as alleged calls for violence against Mr. Friedland on social media. The respondent, Mr. Sandler, did not request a hearing, so that order remains in effect for the full 2-year period that was ordered back on March 13th of 2026. I have reviewed the submissions from Mr. Friedland. Well, I'm going to address what Mr. Sandler brought up, wanting the court to consider a mutual restraining order. I'm not in a position to do that. If there is conduct that you believe Mr. Friedland is engaged in against you that constitutes harassment, I would suggest that that is something that you can pursue through the courts in the state of Florida. I don't pretend to know what the laws are down there, but that is always an option that you might have. But again, I'm not going to weigh in on evidence or allegations just based on your statements here today. So what the court is to consider today is whether or not I consider Mr. Sandler to be in contempt of court for the alleged or the posts that Mr. Friedland has provided to the court from, I believe, April 20th and April 28th were the dates. In reviewing those, I note that Mr. Sandler is not addressing Mr. Friedland directly. He is mentioning him in one instance by name, in another by his it's the blog name, I believe. And I do not see that there are any specific threats or any calls for violence against Mr. Friedland in those posts. Those aren't necessary requirements to find that harassment has occurred. But given all of the circumstances, given that this is the first time Mr. Sandler is appearing before this court, as there was not a contested hearing when the HRO was put into place, what I'm going to do is I am not going to find Mr. Sandler to be in contempt of this court. But Mr. Sandler, I want you to tread lightly. I would suggest that you review the Minnesota statute's definition of harassment, and that any references to, and I'm not going to issue an overly broad order that says that Mr. Sandler is not able to refer to Mr. Friedland in any way, shape, or form. Obviously, we've got some First Amendment implications here as well. However, Mr. Sandler, you should look at what constitutes harassment under the Minnesota statutes. Certainly, that would include anything where you are calling for any type of violence or retribution against Mr. Friedland. So again, you are being put on notice at this point regarding what is said about the petitioner, Mr. Friedland. I'll let you know that if at any time I do find that you are in contempt of court or believe that you have been harassing Mr. Friedland in the future, I think the better course, the more appropriate and practical approach in these cases is what the Minnesota statutes allow me to do, and that is they allow me to contact the prosecuting authority to look into whether then there has been a criminal violation of a harassment restraining order. So under Minnesota law, if a person knowingly violates a harassment restraining order, they can be charged criminally with that offense from a misdemeanor, depending on a person's priors, all the way up to a felony, depending on the nature and number of prior offenses or convictions that a person has. So, Mr. Sandler, I hope you understand. At this point, I'm putting you on notice with regard to harassing Mr. Friedland with that order in place. Again, I would point you to Minnesota statute with regard to what constitutes harassment. So you can look that up yourself. I'm not going to get into, different things that may or may not constitute harassment because there is an unlimited number of possibilities, and I don't want either of the parties to misunderstand what would be allowed. So again, I'm going to refer you to that statutory definition. So the harassment restraining order remains in effect. It is a one-way harassment restraining order prohibiting Mr. Sandler from harassing Mr. Friedland, and I am not going to find Mr. Sandler in contempt of court at this point.
Your Honor, I do have one question for you. May I speak?
Yes, Mr. Friedland.
Thank you. I appreciate your candor and your warning to Mr. Sandler. I would like clarification going forward. I would respectfully ask whether the court's order from March 13th includes indirect identification and public references to me through my publication background or other unmistakable descriptors, even if it is not my exact name being used. My concern is that the respondent appears to understand the existence of the order, but continues testing the boundaries of it through indirect references. In particular, the respondent referenced witness security and alleged informant status publicly while discussing me, despite acknowledging the existence of the temporary restraining order. Those references are especially concerning to me because of the safety implications associated with them. And I simply want to clarity there so that there's no misunderstanding by either party moving forward, and so that I do not continue being publicly targeted despite the order currently in place.
Well, again, Mr. Friedland, what I'm going to say again, I don't want to get into hypotheticals because there's an unending number of hypotheticals that could apply. Indirect identification or even direct, I'm not saying Mr. Sandler can't say anything about you directly or indirectly. However, if I believe that meets the definition, statutory definition of harassment, then that's obviously something that is prohibited by the harassment restraining order. So I can't be any more specific than that, sir. But
I do want to address one more thing, Your Honor. there is a chat in this conversation right now, and there is someone identifying themselves as the Federal Bureau of Investigation in Miami, and they are saying in the chat that they are going to get in touch with me after this conversation, after this hearing. So I just want to make sure that that is in fact acknowledged in this court hearing. There is a continued message conversation between the FBI Miami, and I just want to make sure that that is a truthful person instead of someone that may or may not be impersonating the FBI of Miami. Mr. Sandler is claiming to do a lot of things that may or may not be in the confines of the law. And I believe that the FBI may be reaching out to me for further information about some of the things that he's doing in Florida. I just want to make that on the record. I want that to be on the record.
All right. Well, this is an open hearing. It is now on the record. This is an open hearing, so anybody has the opportunity, because it is an open and public hearing, to appear or to view the hearing. So obviously, if you feel that there is, again, Mr. Sandler, I want you to be aware that any type of harassment would be considered in the future by this court. I don't know who that person is from FBI Miami. Mr. Friedland, I will leave that up to you to whether you want to talk to that entity or not. But at this point,
I do plan to talk to him afterwards.
Right.
Yes.
And if you have concerns that that's not a legitimate thing, you can always contact the FBI field office in Miami directly to determine if they were in touch with or get in touch with you. So with that, Mr. Sandler, you understand where I'm coming from?
Yes, Your Honor. I did want to interject. I do appreciate your time. Just so I understand, because what Mr. Friedland does is he does stuff like this, and then he writes an article about it to try and incite somebody. I'm sure he's going to do that immediately after this. Am I not able to defend myself under the guise of the First Amendment? Are you talking about harassment, threats of violence, things of that nature? That's my understanding. I've never threatened him, but I'm going to defend myself, of course.
Well, again, sir, I'm going to refer you to the statute. I'm not going to get into this might apply or that might apply. So I'll refer you to the harassment statute. If you believe he is harassing you, again, you always have the opportunity to attempt to obtain a protective order of whatever kind they have available for you in Florida.
Going back to the actual statute in Minnesota, though, it requires that I contacted him. And if you research this and look at it, he contacted me in that initial contact. He contacted me with a private number, began to egg me on, and I told him, if you want to see me, come down to Florida and see me.
Well, sir,
not the definition of harassment in Minnesota, not by the statute.
All right. Well, you had an opportunity to have that initial matter heard. There is an order in place. We're not rehearing the initial order. This was a hearing regarding whether you're in contempt of that order. So with that, we're not going to reopen or relitigate the underlying HRO that's in place here. With that, that'll conclude the hearing for today. I need to move on to other hearings. So I do want to make one more statement, and that is that Mr. Sandler has a history of fraud, and he is very disingenuous in a lot of the positions that he has. Sir,
So,
I just want to let that be known. You have a good day, Your Honor. Thank you very much for your time.
All right. Thank you.
And there you just let him weaponize the Justice Department again. Thank you.